people filtering through here. But thank you all for jumping on today for our next first responders meeting. We're really excited to have Magistrate Steve Elliott come and join us today to talk about Probate 101 for first responders. I know that this has been a topic that's been frequently requested, so it's in pretty high demand. So I'll try not to keep you too long at the beginning here, so we can get right into that presentation. But we did have since it was so highly requested, we did have a few new faces register for this meeting. And I just wanted to take a few minutes at the beginning to kind of go through what Direction Home does and what resources that we might have for you to better help you day to day at your organizations, help your teams, help your staff. And this will be recorded as always, so I'll get that out to everyone as well. So if you have to jump off early, no worries, we'll get the rest of the meeting to you, and then you can share it with your networks as well. We will be taking questions, so if you have any that you would like answered immediately while we're on a certain slide or anything like that throughout the next hour, please feel free to unmute and ask your question or use the raise hand feature through Zoom. If not, you can drop them in the chat and we'll open it up at the end for different questions there. And of course, feel free to unmute during that as well. So going ahead and getting started here, I'm Courtney Flickinger. I'm the Communications Specialist at Direction Home Akron-Canton Area Agency on Aging and Disabilities. Our contact information is here if you wanted to jot that down right when we get started here, so you have it. But we serve Portage, Stark, Summit, and Wayne counties, caregivers, family members, older adults. Our goal is to help people age in place independently, comfortably for as long as we can. And then our resource center phone number and our online referral link is there on the slide. So primarily how we do that is through offering different services like health and wellness programs. We have evidence-based health and wellness programming focusing on different information like falls prevention, healthy nutrition, caregiver support, all sorts of things that we can provide to community members, older adults, families, professionals. We can also help connect people with services like home delivered meals, minor home modifications, home health supports, and we have a phenomenal caregiver support program as well for those family caregivers with free information and referrals to different agencies. And then we also have an elder rights department and an aging and disability resource center. Those two, I think, are the primary ones that we would want our first responders to know about, because that's going to be the ones that we think will help you the most in your jobs. Starting with our elder rights department, we do have staff and volunteer ombudsmen on hand to handle complaint investigation and resolution for residents' rights and quality of life in nursing homes and assisted living facilities. We have a director of entitlement rights. Her name is Francine. She's phenomenal. She knows all sorts of stuff about Medicare. Every year during Medicare open enrollment season, she does free Medicare Made Simple seminars. There are still a few on the books for November. So those are free, unbiased, open to the public to attend. There's a couple in person and a couple online, and like this meeting today, one of those will be recorded for future viewing purposes. And then finally, they can also help with long-term care provider selection assistance. And then we also have an Aging and Disability Resource Center. Our ADRC is free to call. Again, that is also unbiased, but we kind of want you to think of the ADRC as your front door to our services. So anyone can make a referral. If you're in a home or you know someone in the community that could use some help with home delivered meals, with isolation prevention, anything of the sort, the ADRC is kind of going to be your starting point for that. To make a referral, we can help connect people with meals. Meals and transportation continue to be our two most requested services, as well as home medical equipment, emergency response systems, and things like that. Alzheimer's and dementia resources. That's how you can get connected with that family caregiver support program that I talked about earlier. And then they can also help with screening and eligibility for different Medicaid and non-Medicaid programming, and conduct in-home. We are back in the homes now, but due to COVID, we did do those telephonically. assessments. And again, contact information is there. Phone number, you can call Monday through Friday during regular business hours. And then referrals can also be made on our website, on our referral page, or through email. A little bit about what that would look like. The screening and assessment, the screening is over the phone. So again, that's that first step for that individual, just trying to get some more information about the situation. And then if they would like to go forward with an assessment, we can set that up as well. It is with a licensed professional, so it will be one of our RNs or social workers from our agency that can go out to the home and just see what's going on firsthand and help that individual determine their eligibility for different programs and apply for them. Again, those can be community resources or non-Medicaid or Medicaid programming. Anyone can call. We can accept referrals from anyone. And those referrals and those telephone calls are free, and they are not obligated to sign up for anything. Let's see. We also have a lot of other fun stuff. I won't get into it too much, but there are so many services available through the Aging and Disability Resource Center. They're the aging experts, so they can help connect people with different food banks and all sorts of stuff. So I always just say, if you have a question about any aging services or resources in the area, just give us a call. They're happy to talk you through it. And then I just wanted to show you what that online referral form looks like. So I'll escape here. If you go to our website, bhad.org, we put it right here on the homepage, the Make a Referral button. So you can click that and it'll take you to a secure referral page. Anyone can make this referral. We are working currently on narrowing down the amount of required information, so it may not always look like this. If there is a required field that you don't know or don't feel comfortable giving, like this morning even, date of birth, social security number, those were required fields. You do not need to fill out all of the information here. We can go off of very little to be able to contact that person about the situation and get them some help. So if you can just give us name, phone number, your contact information, we can take care of the rest from there. But of course, if you have any other information about the situation that made you make the referral, please feel free to include that as well. It'll expedite the process a little bit and give us a better idea of what kind of supports that person might need. So there is a box there for that. And then you just submit it and a screener will be able to respond within about 24 hours. So it's a pretty simple process. And it is a closed loop system. So we do keep track of what happens after the referral is made. So you can keep track of that. So feel free to jot down our contact information here. Again, that's our website link, and I'll drop it in the chat after I stop talking, and the phone number. And then my contact information is there as well if you have any questions, if you have any topic suggestions for upcoming meetings, anything of the sort. And then I will turn it over to Steve Elliott to talk about guardianships, conservatorships, and powers of attorney.
Great, thank you, Courtney. Can everybody hear me? All right, good deal. I haven't done a Zoom presentation in a little while, so I just have to get used to the Zoom nuances again. Like Courtney said, first of all, thank you for having me. Thank you, Direction Home, for putting this on. Being able to talk to our first responders here in the community is an honor for me. I'm honored to be here. I'm honored to hopefully provide some information that can help you not just in your jobs, but in your lives as well. The things we're going to talk about today are things you will see out on the street doing what you do, but obviously a lot of the things we'll talk about today too are going to help you in your personal lives. So I am thrilled to be here. Like Courtney said, my name is Steve Elliott. I'm a magistrate at the Summit County Probate Court. I've been here for a little over 4 years now. Prior to that, I was a practicing attorney here in the area, in the Akron area, for about 15 years. And I specialized in the areas of probate, estate planning. I've probably drafted a couple hundred powers of attorney, the things I'm going to talk about today. I've been in this area of the law for quite a while. And prior to that, I was actually in law enforcement myself. I was a parole officer for the state of Ohio, and I also worked at the CIA down in DC for a couple of years as well. So while I probably wouldn't be called a first responder, I was involved in the law enforcement area for a while. So I've been where some of you are now. So we're going to get started here with guardianships, conservatorships, and powers of attorney. So as we talk about these things today, you're going to hear me say a couple of terms. So I always like to start out with what these specific names mean, because some people don't know because we haven't dealt with them before. But you're going to hear me say fiduciary, a person who has a duty to act for somebody else. As we're talking about powers of attorney, that'll be attorney in fact. Conservatorships will be conservator. And when we're talking about guardianships, the person in charge is the guardian. The principal or the person for whom the fiduciary acts, that's a nice legal way of saying the person that needs the help. So we have the person making the decisions and the person that needs the help. So the person that needs the help with powers of attorney is the principal. In conservatorships, it's the conservatee, and in guardianships, it would be the ward. So as you hear me use those phrases throughout the presentation, that's what I'll be talking about there. When we talk about these different relationships, to me, there's just a couple of things that differentiate them. Who starts it, and is the court involved? That's the biggest difference between these topics. And just something to mention, Courtney, Lisa, and I were talking before we started here. If you have questions, feel free to drop them in the chat box to Courtney, or raise your hand or unmute and tell me to be quiet for a second. Whatever is best for you. I'm happy to answer questions as we go. So who establishes the relationship? So the person in charge, the person in charge starts guardianships. So the person who's going to make the decision is guardianships, and I said rep payee there. Rep payee is not something I'm going to talk long about, but a representative payee is in regards to Social Security and veterans benefits, VA benefits. The VA and Social Security don't care if you have a power of attorney. They don't care if you're the guardian. They want you to apply and require you to apply to be representative payee. The court's not involved in that. And again, the person who's trying to provide the help starts that. So if somebody is on Social Security and you want to be in charge of those assets, even if you're the guardian or power of attorney, you still have to apply with them to be rep payee. So that's one of the things I just like to gloss over to talk about, because that is something that a lot of us deal with. Court involvement and is established by the fiduciary is the guardianship. So the court is absolutely involved in guardianships, and the person that wants to be guardian actually files the application. So the person that needs the help, or the principal, they start powers of attorney. So you can execute a power of attorney today if you want to. You'd be the person that needed the help in that power of attorney. You're the one that starts it, and the court's not involved. And conservatorship is established by the person that wants the help, but the court is involved in those. And again, we'll talk about the guardianship, power of attorney, and conservatorship as we go forward today. So here is a very, very corny attorney cartoon. You see three kids standing there. The one says, I have the power to fly. Jimmy has the power to see through things, and Larry has power of attorney. I know, terrible. But I like to start with this just to drive home the fact with powers of attorney, it is a powerful, it's a powerful tool that you're going to give somebody. You can think of it as a superpower, like the cartoon says here. When you sign a financial power of attorney or a healthcare power of attorney, you are literally giving somebody else the ability to make decisions for you. So I always like to drive home, this is a powerful tool. And if you are going to grant somebody power of attorney, first and foremost, you have to trust that person. If there is any question as to the decision this person's going to make, don't make them your power of attorney. Don't make them your attorney in fact. So just something to keep in mind as we go forward here. So with powers of attorney, we have, there's several different types out there, but the three we'll talk about mostly is the general or financial power of attorney, the healthcare power of attorney, or a limited power of attorney. You'll also hear me say durable throughout the presentation. A durable power of attorney just means that that power lasts beyond your incapacity. If you become incapacitated or incompetent and you want that power of attorney to maintain and keep their power, it has to be a durable power of attorney. So I think throughout my 15 years of practice, I don't think I ever drafted a power of attorney that wasn't durable. The whole point of a power of attorney is to have somebody make decisions for you if you're not able to. So if you've been deemed incompetent and it's not a durable power of attorney, then that power of attorney lapses, it goes away. So you want to make sure that they are durable powers of attorney if you want that person to be able to make decisions for you if you're not able to. In powers of attorney, the powers can be broad or very limited, as you see a limited power of attorney there. The best example that I have for limited power of attorney, I always use Lisa Mansfield. She's from the probate court. She is on this meeting as well. If I was leaving town, but I was selling my house, I could grant Lisa a power of attorney to sign the documents to close on my house. So she could sign the deed and all the financing documents, things like that. So a limited power of attorney is that I want to give somebody just this one power, or for this period of time. So if you limit what the person can do by time or what they're able to do, that would be a limited power of attorney. And then general financial powers of attorney and healthcare powers of attorney, those are generally broad. Pretty much covers anything. If you want somebody to have the ability to act on your behalf, that's something you need to think about. What exactly do I want them to be able to do? And it is limited to what's in that document. So keep that in mind. And also it can be a springing power of attorney or immediate. So an immediate power of attorney is I sign it today, and the moment I sign it, it takes effect. So if I have a financial power of attorney, and it's just a general financial power of attorney, and I sign it, at that moment, the person I give the power to can use it. So they could write checks, cash out my bank accounts, do all of the things that I can do with that financial power of attorney if it's an immediate general power of attorney. If it's a springing power of attorney, something has to happen before that document springs into effect. Usually it's tied to my ability to make that decision for me. So if I'm deemed incompetent or I'm incapacitated, then that power of attorney kicks in or springs into effect. That's how it got the name springing power of attorney. Healthcare power of attorney. This is, our court actually provides these. So if you need a healthcare power of attorney, you can get it on our website. We also have paper copies here at the court. Feel free to swing by and grab one or several for family members. We want you to pass these around and make sure that everybody has one. But a healthcare power of attorney is always springing. So what that means is it doesn't take effect until the person is unable to make that decision for themselves. Okay, so as the principal, I can make my own decisions up until that power of attorney springs into effect, and you can't be overruled by the attorney in fact. So if I'm walking out of the office today, I get hit by a bus and I'm at the hospital, I'm unconscious and I need brain surgery. My wife, as my healthcare power of attorney, can walk in with that document and consent to the brain surgery. She can sign all the consents necessary and make the decision to have that surgery done. So if I get hit by that same bus, I'm in the hospital and I'm in pain and I'm laying there, but I'm still conscious and I say, give me pain meds. My wife can't walk in with that power of attorney and say, no, I'm his power of attorney. Don't give him pain meds, make him suffer. So they can't overrule you and what kind of care you want if you're able to make that decision for yourself. So you sign that power of attorney today. That doesn't take effect immediately, but that person, I guess we'll say, is standing in line waiting. So if something happens that you can't make that decision at that point, then that healthcare power of attorney kicks in and they can make decisions for you. Generally, powers of attorney, healthcare powers of attorney are pretty broad. So they can make any healthcare decision that you're able to make unless you limit it. And as you'll see, I saw Lisa drop the power of attorney form in the chat box. There's a link to the power of attorney if you need one. But as you look through that, you'll see there's some spaces on there where you can write specific instructions. Through my 15 years of practice, I had 2 people ever limit somebody's healthcare power of attorney. One was somebody wrote that they would never want to receive blood products for religious reasons. So they didn't want a blood transfusion, things like that. So they wrote that in there. The other one was I had a guy who said he never wanted to have open heart surgery. I don't know why. I don't know what his fear of was it, but I advised him not to write that in there because you never know what might happen. But he wrote that in there. I would never want to have open heart surgery, so they couldn't make the decision to have that. When he left the office, I wrote a nice letter that said, I advised you not to put that in there, but you put it in there anyway. So those are a couple of things that you can see. By law, there's a few things that they can't make decisions on. So if you were pregnant and they were going to make a decision in regards to your healthcare that would terminate the pregnancy, they can't make that decision unless the pregnancy is threatening your life. So there are some things, here and there that are limited in the healthcare power of attorney, but they are pretty broad. One of the other things in the healthcare power of attorney is if you have a living will, not something I'm going to talk a lot about today, but a living will is a document you sign now that says, if I'm in a permanently unconscious state, or to someone like me who's not in the medical field, that means brain dead. If you're permanently unaware of yourself and your surroundings, you're unable to feel pain, and there's no brain function, that's a permanently unconscious state. So not a coma. A coma, you still have brain function, you're just unconscious. This is if you're brain dead. So if you're brain dead or in a terminal condition with no chance of recovery and death is likely to occur, if you have a living will, that document says, don't keep me alive artificially. So if you have a healthcare power of attorney and that living will that Lisa just dropped in the chat box there, that living will kind of trumps the power of attorney, but just in those two situations. If you don't have that living will, then the healthcare power of attorney, they can still make the decision on whether you should receive life-sustaining treatment. So I say general powers of attorney, general financial power of attorney, durable power of attorney, all of those things kind of get used interchangeably as people talk. There's a little differences in the legal world, but I'm not going to bore you more by talking about all those little differences. So if you hear financial, general, durable power of attorney, those pretty much people use interchangeably. And again, those can be springing or take effect the moment that you sign them. And whether you have a springing or an immediate, that's a decision that you need to make. Again, that general, you sign it, they can take action right now. With general powers of attorney, there is no court involvement, like we talked about at the beginning. This power, they can use this document and the court has nothing to do with it. So in regards to that, there are no accountings required either. So this person's spending your money, transferring money, you opening accounts, closing accounts, and nobody's overseeing them except the financial institution. So the court's not involved at all. So the attorney, in fact, owes a fiduciary duty to the principal. What does that mean? It basically means that they have to use your funds for you and or what you would use them for. So if you give somebody the ability to make financial decisions for you and they cash out all your accounts and go to Vegas, they've breached their duty to you, and you could sue them. But that's the problem with it. The money's gone already, but you could sue them for breaching that duty. So I always, give those warnings. They could steal your money. In my 15 years of practice, I could tell people the worst case scenario because that's what attorneys think. We always think about, well, what's the worst thing that could happen? That's what we get paid to do. So I would say 99% of powers of attorney executed aren't abused. The person does what they're supposed to do, and we never hear about it in the court system. But there is that 1% out there. I did have a client one time who had a general power of attorney. He named his wife as the attorney. In fact, they were married for over 20 years. And he found out that she had a drug and gambling problem the day he was served with foreclosure paperwork on his house, because she had gotten a loan on the house that he didn't know about. She had the power to sign. She signed off on it, got a loan on the house. She used the money for drugs and gambling, and he didn't know about it until, it was too late. So just, again, I give those stories just to say, hey, make sure you trust the person you put on there. But most of them, we don't have those issues. If they do something wrong during life, the person so if I sign that power of attorney granting Lisa the power and she takes off with my money, I can sue her in civil court to try to get that money back. If she steals my money and then I die, then my estate can always sue her to try to get that money back for my estate as well. Creating the power of attorney. Again, the only power the person has is what's in the document. So if you limit it in any way, it's limited, period. If you say, Lisa's going to be my financial power of attorney, but she doesn't have the ability to write checks, and then I get hit by that bus and I need a check written to pay my power bill, she can't write that check because that's what I put in that power of attorney. So keep that in mind as you have these documents drafted. And then certain transactions have to be specifically named in that document. Stock transfers, safe deposit box access, tax returns, and giving gifts. Those are just some examples of things that have to be named in that power of attorney for the person to have the power to use it. There are some issues with powers of attorney, and if you have a power of attorney, you may have run into some of these. First, certain institutions don't accept them. We already talked about that. Social Security and VA. They don't care if you have a power of attorney. you have to apply to be rep payee. And then there are some, especially banks lately. I don't know if anybody works in the banking industry or insurance industry. I don't like to throw people under the bus, so I apologize if you do. There are some banks and insurance companies that are being difficult, especially more recently than we've seen in the past, with powers of attorney. I've heard things like they're requiring them to be dated within a certain period of time, or they want their specific bank, investment company, or insurance company specifically named in that power of attorney before they'll honor it. Neither of those things is true. The statute does not say that. That's an internal policy on these banks' part. And having to be dated within a certain period of time is kind of ridiculous. When you sign a power of attorney, it stays in existence forever, unless you put a date in there that it's going to stop, or if you die, or you revoke it. You can always revoke these documents. As long as you're competent, you can revoke a power of attorney that you sign. So I could sign a power of attorney now while I'm relatively young. And then 30 years from now, somebody might need to use that power of attorney. If a bank says, hey, that power of attorney needs to be dated within the last 10 years, now all of a sudden I don't have that power of attorney for that bank. If a bank or an institution doesn't honor a power of attorney, you can file a lawsuit to make them. A lot of people don't do that because by the time you file that lawsuit, go through everything, it's going to be expensive and time consuming. But that's what you would have to do. You'd have to sue them to force them to accept that power of attorney. Or if there isn't a power of attorney in place for them, then you would have to file guardianship if the person isn't competent and needs the help that way. So you may have to file guardianship because of that. A couple of pointers with powers of attorney: always keep the original. Don't give the original to anybody. The power of attorney, all the ones that I drafted said the copy is just as good as the original. But that said, keep the original. Give copies. If it's possible, have the person or the principal, the person needing the help, have them give it to their financial institutions while they're still competent. Have them go to the bank and say, hey, I have a power of attorney. I've appointed Lisa Mansfield, my attorney in fact. Here's the power of attorney, so that they know it's in existence. If they know that and it came from the person, they're more likely to honor it that way. So that's just a pointer to try to make things a little smoother for them. If you're going to transfer property with a power of attorney, it has to be recorded with the recorder's office, just like your deed. So if I give Lisa Mansfield the ability to transfer my house, they have to file that power of attorney in public record, just like the deed. And if it is a springing power of attorney, again, usually because a person's incompetent or incapacitated, you have to have the documents to prove. When I wrote a springing power of attorney, it usually said, this power of attorney only takes effect if 2 doctors examine me and determine that I'm unable to make the decision myself. So if that's what that power of attorney says, you better have 2 letters from 2 doctors that say Steve can't make his decisions anymore. Because if you don't have that, then they don't think that power of attorney is active. So you have to have that documentation if you're going to use a power of attorney such as that. Once you sign this power of attorney, how do you terminate it? You can revoke it at any time. You can tear it up, burn it, write void on it. If you do those things, it's revoked. If you sign a new power of attorney naming somebody else, it revokes the old one. So it's the most recent power of attorney that you have is the one that's in effect. If you are married and you name a spouse and you get divorced, by operation of law, they're automatically, they are no longer your power of attorney when that divorce happens. If it's not a durable power of attorney, your incapacity terminates it. So again, if you want this decision maker to have that power, if you're not able to, make sure that it is a durable power of attorney. It doesn't expire unless the power of attorney says so. So if in the document it says it expires, January 1st of 2023, that's when that document expires. If it doesn't have that, it lasts until you revoke it some other way. This is probably one of the biggest misconceptions out there. People will come into the probate court and say, hey, my dad died, but I have his power of attorney and I want to transfer his bank accounts. That power of attorney dies with the person. So if you have a power of attorney for somebody and they die, it's no longer, you can't use it for anything anymore. The moment that person passes away, then the estate process kicks in. And that's a whole nother presentation talking about the administration of estates, which I'd be happy to give if you ever want it. But that's a whole different presentation. So death terminates the power of attorney. We, as a court, we terminate powers of attorney often with guardianships. If there's a guardianship and somebody's appointed guardian, we'll oftentimes revoke that power of attorney. That way you don't have two decision makers at the same time if they're different. We will definitely revoke it if that power of attorney is doing things they're not supposed to. And that is another reason that you might need a guardian. If you name somebody as a power of attorney and they're doing things they're not supposed to, you might want to, somebody can revoke that power of attorney or file for guardianship to get that power of attorney revoked so that person can stop stealing. And then again, if you have that living will and they're terminally ill, that will terminate a healthcare power of attorney. So general powers of attorney, remember, they can be springing or they can be immediate. Healthcare powers of attorney are always springing. They only take effect when you can't make the decision for yourself. So some of the pros and cons of powers of attorney. Pro, they are simple and quick to establish. The healthcare power of attorney, Lisa sent it to you. If you would have filled it out and had two people witness your signature while I was talking, you would have a power of attorney. That's how easy it is to get it done. So it can be easily done, quick and simple, and obviously inexpensive. The court's not involved. That's a pro and a con. If the court's involved, again, it might be more expensive. You might have to have an attorney. You have to ask for permission to spend funds in a guardianship. But as the court, where there is a safety net in guardianship proceedings with powers of attorney, we are not there as that safety net. So it's a pro to have the court involved sometimes, and it's a con. It's kind of like the joke with police officers, where some of you might be, you don't like police officers till you need one, right? Same with attorneys. You don't like attorneys until you need one. Same with the court. You don't like the court till you need one. So that's why it can be a pro or a con. A pro with the power of attorney is the principal can revoke it. So if I sign that power of attorney, I can revoke it. That's also a con. Oftentimes, if we are diagnosed with dementia or Alzheimer's, things like that, as we start going through that process, I've seen it happen a lot of times where they had a power of attorney, they get mad at the person they've appointed and they tear it up. So they've just revoked that power of attorney, even though they might not have the ability to do it. If they destroy the document, it's destroyed. So while it's easy, it's a pro for the principal to revoke it, it's also a con. A pro, it survives the incapacity of the principal, which might eliminate the need for guardianship, which is the main reason I talk about powers of attorney in this presentation. If you have a healthcare and a general power of attorney and you become incompetent or incapacitated, it eliminates the need for them to file for guardianship for you. So as long as they're doing what they're supposed to, now you've appointed the person you want to have making those decisions for you instead of the court appointing somebody. So that's definitely a pro powers of attorney. It survives the incapacity and lets you pick who you want to be in charge. A pro and a con is the principal has authority at the same time. Anytime you have more than one decision maker, it can be a con. But at the same time, as you are able to make your own decision, you can make your own decision. A con, the power, sometimes the power doesn't work like we talked about. If a bank's being difficult or an insurance company's being difficult, they're not honoring them. So sometimes they don't work. So that would be some of the cons. Conservatorships. This is, at the bottom, you can see there, I say a POA with court oversight, or I call it a power of attorney on steroids. A conservatorship starts when a person who can't manage their affairs for some reason, but they're not incompetent. That is a key. If somebody becomes incompetent, they can't start a conservatorship. But if I have a medical issue that I can't get around well, I can open up a conservatorship asking Lisa Mansfield to be my conservator so that she can transact my business for me because I'm not able to physically. So again, you can't be mentally incompetent, but I decide who I want to be my conservator. And then I, along with that person that I want, we file that with the probate court. So we petition the court for the conservatorship. And once that petition's filed, we actually have to have a hearing on the conservatorship. And during that hearing, we have to talk to the applicant and also the person they want to appoint to determine, to make sure that the conservatee wasn't forced into it. So it wasn't one of these where, hey, I'm going to be in charge of your money. No, I don't want to do that. Well, we're going to do it anyway. So we make sure the person actually wants it to happen. And then we also make sure that the conservator is suitable, including having a background check done. So we want to make sure that that person is able to and has the ability to act as conservator. So we make sure that at that hearing. The parties agree on the powers, so it's just like a power of attorney. It can be as broad as I want it to be or as limited as I want it to be as the conservatee. But with conservatorship, this is why I call it a POA with court oversight, or a POA on steroids. So all of that sounded just like a power of attorney. I pick the person, I'm the one that starts it, and I can terminate it at any point. The difference between a power of attorney and a conservatorship is the court's involved. So when we're involved, they have to post a bond, they have to file an inventory, and they also have to file accountings. An inventory is, it just tells us what they're in charge of. So if I appoint Lisa, or ask for Lisa Mansfield to be my conservator, then on that inventory, we would have to list, my bank accounts, investment accounts, my house, whatever it is she has the power to make decisions on as part of the inventory. We review it as the court, we approve it or deny it. We may require more documentation, those types of things. And then accountings are required as well. So that conservator has to file accountings and show us what they did with all of the person's funds. So they have the ability to make those decisions and transact business, but they still have to report to us so that we know they're doing what they're supposed to do. So that's why I call it a power of attorney with court oversight. With conservatorships, by the way, they're not very common. There's obviously hundreds of thousands of powers of attorney out there. Right now in Summit County, we have 2,800 guardianships, active guardianships in our case, in our court. Conservatorships, we have about 10. They're not used very often. And I think it's because the power of attorney is just easy to have done. So most people that would want to enter into this type of an arrangement probably just do a power of attorney, so they try to keep the court out of it. As an attorney, I had a lot of people ask me if I would be their power of attorney, but I would never do that. I would say I would act as conservator, because if it's somebody that I don't know, it's a client, I would want the court's oversight so that there aren't any issues with, them saying I did something improper. So if there was a situation like that, then maybe a conservatorship would be more appropriate, I guess. The terminated conservatorship, the conservator can terminate at any time, just like a power of attorney. They basically file something with the court that says they want to terminate the conservatorship, and then we'll terminate it. We may have a hearing on it and then terminate it at that point. If the person dies, just like a power of attorney, just like a guardianship as well, when that person dies, that conservatorship dies with them. So once they die, you can't take action on that conservatorship anymore. And I think another reason conservatorships aren't very popular is if you're deemed incompetent, that conservatorship lapses, it's terminated. So if, unlike guardianships where it survives incompetency, in fact, guardianship doesn't start until you're incompetent. With a conservatorship, if you're deemed incompetent, the conservatorship terminates, and then a guardianship would have to be established at that point if you still needed the help. Conservatorship pros and cons, obviously, just like the power of attorney, you can pick who you want to be conservatee. Another pro is you have a bond. So I think I forgot to mention that. As part of the court oversight, you have to post a bond. And think of that just like in the criminal sense. If somebody posts a bond, it's there to pay if they don't show up. So same here. That conservator posts a bond. So if they take the money or use the money for something inappropriate, that bond pays out to make sure the person that needs the help still has the funds to take care of their living. The court's involved, which is a pro and a con, and you can see the reasons there. More paperwork, more time, more fees. At the same time, you have that safety net of the court watching over the conservator, making sure they're doing what they're supposed to do. Another pro and con, just like the power of attorney, the person can terminate it. So if they start becoming incompetent, they can say, never mind, I don't want to do this anymore. So it can be a pro and a con there as well. And then another pro is you can tailor it to what you want. So when you file that conservatorship, it can be just like a limited power of attorney. You can make it as broad or as limited as you want. So if you just need somebody to help you with your bills, but you can do everything else, you can make the conservatorship just for that. And the last thing we'll talk about today is guardianships. Like I mentioned, there are 2,800 active guardianship cases in our court. That's one of many types of cases that we handle here. And guardianship is a formal legal relationship where a person who is competent is appointed by the probate court to help a person that's unable to manage their affairs for themselves. whether it's because of a mental issue, some type of physical impairment that maybe like a TBI, or if there's a developmental disability. Those are, the most oftentimes guardianship is needed is in those situations. But if a person is so mentally impaired as a result of one of those things that they can't make decisions for themselves or their property, that's when a guardianship is needed. And you can be appointed as guardian of the person or the estate or both. So as you have the financial power of attorney and the healthcare power of attorney, you have guardian of the person, like the healthcare power of attorney, and guardian of the estate, like the financial power of attorney. So you can have any of those three: person, estate, or person and estate. With guardianships, the authority can be granted temporarily or in an emergency situation, and we'll talk about that a little more in depth here in a couple minutes. And with guardianships, the thing that we always have to emphasize, and the thing I specifically have to find when I do a guardianship, is that there's not a less restrictive alternative available. So if I can get the help through a power of attorney and somebody files for guardianship, if there's a power of attorney in place and that person's not abusing it, they don't need a guardian. They have a less restrictive alternative available, so we let that power of attorney continue doing what they do. When we grant guardianship, and this is why we have that less restrictive alternative thing in our mind, when we grant guardianship, we are taking away that person's rights to make decisions for themselves. So when we do that, we want to make sure there's nothing else that can be done first. So before we grant those letters of guardianship, we want to make sure there isn't something else that can be done to help that person, short of taking all of their rights away from them. So that's something that we always look for and keep in mind as we move forward. So when is guardianship necessary? If a person doesn't have a power of attorney or you can't find a power of attorney, so if you sign a power of attorney today, make sure you tell the person who you've appointed that you've appointed them. Make sure they know where to find that document, because if they can't find a power of attorney, then you might have to have a guardianship. If that attorney in fact is unable to serve or they're unavailable, so if I just name my wife and my wife dies before me, now I don't have somebody named in that power of attorney, I might have to have a guardianship because of that. So in those power of attorney documents, name a primary and a secondary, and if you have three people, name the third, so that you have somebody standing there ready to take action if one of your other people passes away. If power of attorney doesn't name a specific power that's needed, you might have to have a guardianship. Self-neglect or lack of cooperation. In your guys' business, I'm sure you see that a lot. Self-neglect, or the person isn't cooperating with the power of attorney. So while I might have the power to make decisions for somebody in that power of attorney, if they're just ignoring that and they're not listening to the attorney in fact or the doctors, then you might need guardianship. You can't really force somebody with a guardianship, but with a guardianship, then that person absolutely has the power to sign documents and things like that. If there is a power of attorney in place and they're exploiting the person, then you'll need guardianship to make sure that stops happening. If there is a power of attorney that's not durable, or again, if you have a conservatorship and the person's deemed incompetent, that's when you might need a guardianship. So with types of guardianship, I mentioned emergency guardianship earlier. Like I mentioned, we have 2,800 active guardianship cases. And I would probably say in 2,700 of those guardianships, when they were filed, the person filing them thought they were an emergency. And they were, for that person. But legally speaking, an emergency guardianship is one, it's only good for 72 hours. It can be extended for 30 days. But to qualify for an emergency guardianship, it has to be reasonably certain that immediate action is required to prevent significant injury to that person or their estate. For example, the person needs the brain surgery example that I gave earlier. If they don't have brain surgery, they're going to die. Well, obviously, that's reasonably certain that immediate action is required to prevent significant injury. In that situation, an emergency guardianship would be appropriate. We've had emergency guardianships for somebody who has gangrene and needed to have something amputated, but they wouldn't agree to it because the infection was making them not make sound decisions for themselves. So an emergency guardianship is needed for that. An emergency guardianship, like I said, everybody's guardianship is an emergency, but for an actual emergency guardian, that's what has to happen. It's basically, your life's in danger, or your life and limbs in danger, or somebody is actively stealing money. And if you don't stop it, all of somebody's funds are going to be gone. That's literally the only time an emergency guardianship can be used. Limited guardianship is just like a power of attorney. If you just need somebody available to sign documents, you can do a limited guardianship for that. And then we just have full guardianships as well, which is like we talked about. They make all decisions in regards to their person, estate, or both. And then there is a thing such as it's called an interim guardian. If a guardian's appointed and they can't make decisions for whatever reason, we can appoint somebody to step in and make decisions for that ward if the main guardian is not available. Steps for the guardian.
I have a question for you while we're on that slide, if you don't mind. Between emergency guardianship and DNRs, how do those two interact in an emergency situation?
Great question. DNRs, if somebody has a DNR, I don't know if that's what the question was intended to ask. If somebody has a DNR and they signed it with their doctor and their doctor put it in their medical record like they have to do with DNRs, that takes effect. If they've made that decision and they've signed that DNR, that do not resuscitate order, that trumps an emergency guardian. So if my wife had a DNR order and I wasn't happy with that, I couldn't get a quick emergency guardianship to overrule her DNR order. So if you've signed one, that is what controls. So I hope that answered the question. If not, please.
Yep.
Okay.
Thank you.
All right. Steps of the guardianship process. Let me caution you, it's not fast. Okay, so if a guardian's needed, the process takes some time, and it can go a couple of different ways. To start the guardianship process, an application is filed with our court by the person that wants to be guardian. They have to file also an addendum with it, which is another form for our court, with a statement of expert evaluation and a criminal background check. So you have to have a BCI check done if you're applying for guardianship. So all of those things have to be part of the filing. That statement of expert evaluation, let me tell you what that is. That is a form with our court that has to be filled out and signed by a doctor. And that doctor on that form says, Steve is incapable of making decisions for himself or for his property. And that you have to have that statement from a doctor before you can file guardianship. So if, you feel as though, Lisa feels I'm not making good decisions for myself and she files a guardianship application, if she doesn't have that statement of expert evaluation, then the guardianship process stops there. You have to have that statement from a doctor that says that person needs the help and they can't do it themselves. Once that's filed, one of our 4 magistrates, we have 4 magistrates here at the court, one of us gets that filing and then we review it to make sure everything's there that they need. The third step in the process, once we approve it and say everything's good, we set it for hearing. And then at that point, we have a court investigator here at the Summit County Probate Court that goes out and serves the ward with notice of the guardianship. So I don't know, there's a movie floating around out there on Netflix. I can't remember the name of it, but it's about somebody who got guardianship of somebody and they didn't know about it and they took all their money. And you hear stories about that in the news. That won't happen in Ohio. Because if a guardianship is filed, we go out and serve the ward or the person that is going to be placed under guardianship potentially with notice that it happened. So our court investigator, we have 3 of them. They will go out and serve the ward with notice that guardianship. Hey, guardianship's been filed. Here's who filed it. Here's when the hearing date is, and here's what your rights are. So when guardianship's filed on somebody, they have the right to be present at the hearing and contest the guardianship. So if they don't want it, they can fight it. They have the right to have an attorney, and if they can't afford it, the court gets them one. They can have a family or friend present at the hearing while they're going through it. So if they need some support, they can have somebody there to help them. And they also have the right, and probably most importantly, to an independent expert evaluation. So that situation I was talking about where somebody files guardianship, they didn't know about it, and they get all their funds and steal them. Here, if somebody files guardianship and you say, wait a minute, I don't need a guardian, you have the right to an independent expert evaluation. So you can go to another doctor And if that doctor says, listen, Steve doesn't need a guardian. He's fine. He can make his own decisions. They may be questionable decisions at times, but he can make his own decisions. If you have that, then that guardianship doesn't go any further either. If somebody tries to do something underhanded like that, you can prevent it with that independent expert evaluation. Then the court investigator comes back and tells us what the person said and what they wanted. If they oppose the guardianship, we appoint them an attorney at that point, unless they have their own. If they have their own, then we just get in touch with that attorney and let them know what's going on, and if they need to, step forward and be part of the guardianship process. And after all of that happens, then we have the hearing on the guardianship. So you'll hear, or if you haven't, they say guardianship proceedings are not adversarial. They're in rem proceedings. That means that they're there to help people make decisions about their property and themselves. I've never had a guardianship hearing that wasn't adversarial. If somebody doesn't want a guardianship and they fight it, it's adversarial. But that's the point. And the point for us as the court is, when we say it's not adversarial, it's in rem. Our job at the court is we want to gather all of the information that we can and make a decision for what's best for the person that needs the help. So just because somebody files that guardianship doesn't mean it's going to happen. We determine if it's in their best interest. If they're not able to make decisions for themselves, such as medical decisions, and they're refusing treatment because they don't understand, they don't have the ability to understand what's going on, we can appoint a guardian to make a decision that's in their best interest. If the person consents to the guardianship, the hearing is literally just with the magistrate, the person who applied, and maybe the ward. And we just appoint them at that hearing. If they oppose the guardianship, we have to have a full hearing at that point. So if they're fighting the guardianship, we actually have that hearing where everybody shows up, the magistrate or the judge, the proposed ward with their attorney, the applicant, the applicant's attorney, oftentimes other family members, and we have to have a guardianship hearing. This is where I always plug powers of attorney. Guardianship proceedings are tough. They're hard. And the reason that they're hard is if I apply to be guardian of my mom and my mom doesn't want a guardian, we have a hearing. Well, I have to go to that hearing and testify why my mom's incompetent. I have to say, the doctor says she can't make decisions for herself. She leaves the stove on all the time. She's given all of her money away to, people that are exploiting her. So you have to sit there, in front of that person and say, this is why they're incompetent and why they need a guardian. And it's a tough situation. So that's why when I say it's not an adversarial proceeding, it really is. So that's why if you have that power of attorney in place, hopefully you can avoid having to go through guardianship. Once that hearing happens, I issue a decision on who's going to be appointed guardian. So that guardian has to be suitable to serve. So just because somebody applies, again, even if they need a guardian, it doesn't mean I'm going to appoint them. They have to be suitable. And if they're not suitable for whatever reason, like a criminal history of stealing money from people, yeah, we're probably not going to appoint them as guardian of somebody's funds. So they still have to be suitable to serve as guardian, and we make that determination. So then I issue that magistrate's decision, and then the judge enters a final judgment entry appointing the guardian. Once that guardian is appointed, we give you what's called a letter of guardianship. And that's just the document from the court that says Steve's been appointed guardian of Lisa, and he has the right to make decisions for her. So that's what you can use to show people that you've been appointed guardian. Accountability with guardians, since the court's involved, there is accountability. And we always look at, like I mentioned earlier, what's in the best interest of the ward. All decisions made in guardianships are for the benefit of the person that needs the help. In guardians of the person, they have to file an annual report. So once a year, you give us an update. How's Steve doing? Has he been going to the doctor? What's he involved in? Everything going okay? So you have to file that annual report every year. With guardians of the estate, you have to file that inventory like I talked about with conservatorships. They have to post a bond, 2 times the value of the estate. You have to file the accounting, and the guardian also has to get prior approval before they spend any money for the ward. So if the ward is living at home and the electric bill needs paid, the guardian has to ask us before they can pay that bill. So that's how the court acts as that safety net. The guardian has to ask before they spend any money. And there's a guardianship account at a bank. The bank wants to see that order before the bank lets it happen. So that's the way that the court is involved in guardianships as we go. The court is the superior guardian. You'll hear that in guardianships. We have those 2,800 guardianship cases I was talking about. That means there's 2,800 guardians out there, but each one of those guardians reports to the court. So the court is the superior guardian. And is in charge of those guardians and make sure they do what they're supposed to do. Guardians of the person can also ask the court. So if there's a tough situation medically, and that guardian of the person that isn't, real comfortable making that decision, they can ask the court. We could have a hearing and then help them make that decision if they can't. And then, like I mentioned, guardians of the estate have to get approval from the court before they can spend any of the money. And on the next slide there, you can see at the bottom, I put it on there again. Best interest of the ward is what always controls. Whatever's best for them is what we want to do. When a guardianship is established, how does it end? The person dies. If the guardian or the ward dies, that guardianship is terminated. A new guardian can be appointed, but they would have to apply if it's the guardian that died and not the ward. If the guardian becomes incapacitated, then obviously that guardianship ends, or they can also resign. If the guardian is not doing what they're supposed to do, we can remove them from the court as well. So that's another way guardianship might end. Or if the guardian is doing something inappropriately, again, we remove them, and then they can be personally liable to the ward or the ward's estate if they took the money. And that's why we have the bond in place. So the bond would pay out and make sure that the ward still got the care that they need. Pros and cons of guardianship. A pro, and again, something here in Ohio that not all states have, notice and due process. If a guardianship is filed, they're informed of it. They know what's happening and they have the right to fight it. And oftentimes they do. And they are provided rights such as an attorney, the right to appeal, all of those things. Another pro is the court's involved. It's that safety net I was talking about earlier with the inventory, the bond, the accountings. And while there is a guardianship, there's a low risk of exploitation. With us being involved in making sure things are going appropriately, the risk of being exploited is lower. Of course, the guardian could go and, mock up a court order and steal all of the money, I guess. But the chances of that happening are lower than with a power of attorney. With a power of attorney, another pro, and something I'm sure all of you have seen, is you can force placement. So if somebody needs to be in a facility and they're unsafe unless they're in a facility, a guardianship through the court, we can enter an order that says Steve needs to go to a facility. He can't live at home anymore. And there's broad authority. Some of the cons, just like with everything else that we talked about already, complicated, courts involved. There's a lot of paperwork. The determination of incompetency can be embarrassing, like we talked about, having to sit there and testify how your loved one is incompetent. That's a con with it, which is, again, why we always provide these powers of attorney to people. And then, with any court process, family hostility, especially if you have two kids that apply to be guardian for mom, the court decides which person's going to be appointed, and obviously that can lead to family hostility. So again, another point of emphasis to get that power of attorney in place. So a summary of everything we just talked about there. The initiation of a power of attorney is with the person that needs the help. Same with a conservatorship. With a guardianship, it's the person that's asking to have the power. The court is not involved with powers of attorney, but they are involved with conservatorships and guardianships. The bond is not required with a power of attorney, but with the other two it is. And then the inventory and accountings follow the same path. Termination of powers of attorney can be the principal or a court. So the person who starts it or the court, we terminate powers of attorney. With the conservatorships, it's a conservatorship or the court. With guardianships, the only way that a guardian is terminated, outside of death or something like that, it's the court. We terminate the guardianship and we enter the order saying that guardianship is terminated. So that was a lot of information in a short period of time. And I hope that people have questions. And if you do, please feel free to ask.
Yep, we do have one in the chat. Please feel free. We'll tackle this one. Feel free to drop any more into there. I noticed in the healthcare POA paperwork on your website, there's a section that allows you to name a guardian and guardian of estate. How does this work when you mention the POA is revoked on death?
So what happens is, and remember, guardianships are revoked at death too. Whether any one of these three tools we talked about today, if somebody dies, they're revoked. Once somebody passes away, the only way you can get power over their finances is to file an estate. and be appointed executor. So we give you the ability to appoint a guardian and those powers of attorney in case one of those situations come up where you might need one. So if, you know, a bank's not honoring that power of attorney, you get to pick the person you want to be guardian. Or if, I'm trying to think how else that might be. If you're, you know, deemed incompetent and that power of attorney, for whatever reason, they can't use it, that's you saying, hey, I want Steve to be my attorney, in fact. So that way we see that, they'll present that to the court so that I can see who it is you wanted to act as your guardian if you had to have one.
Thank you. And then I had one too. This is for everything we talked about is across the state.
Yes. Everything we talked about today is Ohio law. The court process may be different from jurisdiction to jurisdiction, but I mean, every guardianship is the same. You know, they have to file the application with a statement of expert evaluation. You have to give notice to the person, and then they have the right to fight it and so on. But yes, it's throughout the state.
Okay. Any other questions for Steve? Feel free to drop any in the chat while I wrap us up, and we can still tackle them at the end there. But thank you so much for coming to talk. We had some really good presenters this year for our first responders meeting, and this was the last one of the year, so I think it was a good way to end it. So I'll have the recording and everything, and I can send it out to everyone. And feel free to share that as you need to. But I think that's actually all I have. Usually I have like a whole closing spiel, but I don't have very much to say today. So
the last one, that's why.
Yeah. So yeah, thanks again for coming, and thanks for your help, Lisa. And thank you to everyone who took the time out. I don't see any other questions at this time. Oh, is it emphasized to healthcare POAs to have a copy of their paperwork?
Yes. With healthcare powers of attorney, that's a great question. It's something I should have mentioned. If you have a healthcare power of attorney, I would always tell clients, make sure your doctors have a copy of it. And a lot of times they'll ask, and if you ever have to go to the hospital, that is one of the questions they'll ask you. So maybe you're familiar with that. Do you have a healthcare power of attorney? You want to provide copies of that to the doctor, and always, always, always make sure the person you appointed knows where they can get that document. If they don't have a copy of it, let them know where they can get it. Hey, I keep it in the safe in my closet, or, you know, the filing cabinet in the office. I would always tell clients to give a copy of that power of attorney to the person you appointed. Not the original, you keep the original, but give them a copy of it so that if they do have to go make decisions for you, they have that copy in hand already.
All right. I think that is all. Just a lot of thanks, and thanks for the information. So
thank you for having me. I appreciate it.
Yeah.
Thank you everybody for coming.
All right. Thank you. Have a good rest of your day.
Thank you. You too.